Appreciate you all joining us again for another CLE that our firm is putting on. Today we're going to be talking about trademark infringement and how to handle infringement when it occurs, and different enforcement techniques that we've used over the years that have been successful for our clients. And a lot of today's CLE will focus on non-litigation techniques. We're not going to go into a lot of depth on actual litigation strategies because that's for another day, but we're going to talk a lot about sort of the non-litigation side of trademark enforcement. And then at the end, we'll touch a little bit on litigation itself, mainly because of the complexity and budgets that are typically involved in that. So for those of you that might be first timers here, welcome. Gerben Perrott, Eric Perrott is on the call here as well today. We're in the middle of our end of our 17th year. Next CLE, you're going to see we'll be celebrating our 18th year as we get into 2026. We have 7 lawyers and 4 paralegals. We're scattered up and down the East Coast. So we've got folks as far north as Vermont and as far south as North Carolina, and sort of everywhere in between. We're a fully remote firm these days. That was actually a little bit of our nature even before the pandemic. So it's just, we end up not having a centralized office. The client base is from all over. So when you work with trademarks, one of the fun parts about it is you get clients from all over the US and all over the world because it's really a federal practice. So you're not really constrained geographically. So we've had clients all 50 states and over 30 countries around the world that we help. Our firm in the last 17 years has registered over 8,000 trademarks. We've settled hundreds of disputes, overcome tons of USPTO refusals, handled litigation, everything from trademark trial and appeal board matters all the way through federal litigation. So trademarks is kind of what we do. We don't do anything else, but if you have any questions about trademarks, we're normally pretty good. So I know we've had a bunch of people just join the last few minutes. So I'll go through real quick again, sort of what we're going to cover here today. So I want to talk a lot about trademark infringement and how to handle it when it occurs. So first thing we're going to kind of talk about is sort of what is infringement and what is not infringement, because that sometimes is a little surprising to folks. And then we're going to go into a large discussion about all the things you would do to try to enforce a trademark and handle infringement before you get into any kind of litigation. We'll touch on how trademark litigation works towards the end of the presentation, and then a little bit about monitoring to look for enforcement targets, for trademark owners. Kind of just I always start with the basics. What a trademark is. So trademark is a source identifier. It's meant to act as something that tells a consumer who's behind a product or service. So if you look at and you pick up a Nike shoe, you know that Nike Inc. has made that shoe and is behind that product. And as it comes into an infringement conversation, one of the things that we always talk about is that trademark law is actually really a consumer protection law. It's not meant to protect individual businesses as much as it's meant to protect the consumer from being able to tell the difference of source behind a product. So you only really have trademark infringement if an average consumer is going to look at 2 products or 2 services and get confused as to who might be behind which one. And so that's an important note, as we kind of get started here today, just understanding what a trademark really is and who it's meant to protect. Trademarks come in a lot, and there's so many different types of trademarks, and that's also something that folks don't realize. These are just some examples. Obviously, you have a name like Oreo, that's going to be a trademark, but there's many other trademarks that Oreo has. They have a trademark on the actual design that's on the cookie. If you ever pick it up and look at the intricate design, there's protection around that. They have protection around the way the packaging looks. They have protection on the various different products, sub-product names like fins, and even slogans. You can see here, Milk's favorite cookie was one of the slogans we picked out that they have registered. So trademarks, it's not just the name. It can be so many different things associated with a product or service. Anything that really identifies for a consumer. Again, I'm looking at this and I know, oh, this must be an Oreo because I see this design that's on all the Oreos, or, oh, this must be an Oreo because I see this packaging and that's the packaging that Oreos always come in. So if consumers start to make that connection, that's typically where you have a trademark. So getting into the topic of the day, which is infringement. As I just mentioned, you have trademark infringement when there's a company that starts using a similar trademark and consumers are going to get confused. So think of a situation where somebody buys a product and they're dissatisfied with it, and they go to the brand owner and they say, I bought your product and it's a bunch of junk and I don't want it. Well, if it wasn't that brand's product and it wasn't that company's product, but it was somebody else's, that's a good example of a consumer getting confused and having a problem. And you might have a problem with trademark infringement. Typically, you see sort of two, and of course, there's always variations, but two main sort of buckets of trademark infringement. One is sort of the more nefarious kind, where someone's just obviously trying to rip off your client's brand or rip off the product design or whatever it is and sell their own version of it. That's kind of the more nefarious type. Then you have sort of the less nefarious type, which is somebody selects a name, a logo, or a slogan that just happens to look too similar to your client and starts to cause confusion, or you're afraid it's going to cause confusion, and you do some enforcement around that to try to make sure that you don't have a problem. So typically, the first side of this, the more nefarious side, that tends to be more easily handled, although not always handled, with the non-litigation enforcement where you're doing takedowns and other things that we'll talk about in today's call. And then the inadvertent infringement, that's one where you have to be more strategic about your settlement negotiations. And a lot of times that is sometimes where you end up in litigation because the parties don't really agree on if something's infringing or not. So to open the presentation, this is a fresh verdict just issued a couple weeks ago, which is kind of wild. But Beyond a jury found that Beyond Meat infringed on a trademark owned by Vegadelphia and owes them $39 million for the infringement. So so probably a great example of why you don't want to take a case to a jury, because I don't know that a judge would have found this, and I don't know a judge would have found the damages to be as much. But I've read through some of the trial stuff, and Vegadelphia did make a good case here, but it's also a bit of a surprising one. So let's look at the trademarks that were involved. Beyond Meat started using this trademark plant-based great taste. You think, okay, it's not even that good of a slogan, right? I mean, what is that? It's kind of in the trademark world, if you've been to some of our CLEs in the past, we might consider that on the weaker end of the spectrum, almost something that describes the product. It's not really that good of a slogan. Well, Vegadelphia had, to their credit, had a trademark registered for where great taste is plant-based. So kind of the inverse of that. Vegadelphia did try to send demand letters and things, and Beyond Meat basically pushed hard around that slogan. And what came out of trial is Beyond Meat also had some variations of that slogan they were using and never really backed down from using it. Well, the jury said, look, Vegadelphia went out and registered this trademark, and there was a lot of evidence in the record about how much business that Vegadelphia felt they lost because Beyond Meat just basically bulldozed them and bulldozed the use of that slogan and just took over a lot of business that might have come to Vegadelphia because of it, and hence the $39 million verdict. So this would be a case, though, in all honesty, that if we were representing Beyond Meat, which we're not, and we got a letter like this where great taste is plant-based and where plant tastes great taste, we'd probably say to our client, well, yeah, they have a point, they have a registration, but because the trademarks are so weak, you probably have a defense here. And that's probably what Beyond Meat's attorneys were telling them the whole time, is these are really weak trademarks. We don't think that they should be able to enforce this. Well, jury disagreed. And so one of these situations here where if the other, on the flip side of this, had Beyond Meat done a trademark search and we would have almost certainly have seen Vegadelphia's mark. This would have been one where if you're counseling a client, say, look, someone's got a very similar mark here. It would not be unlikely that you get a demand letter or there's some dust up around this. You should proceed with caution or really just find something else. And so I think there's a couple of mistakes along the way that precipitated this verdict, but you can see where trademark infringement isn't cheap. So, you do want to be careful and try to keep clients out of trouble. But, and if your client does have a claim, you can see where, that there's certainly, if they have the money to see it through to trial, which we'll talk about later, as far as the cost of litigation, then there's sometimes some recourse there. So, that being said, that kind of sets the stage for our next question here, which is, how do we really know if you have a trademark that's getting infringed upon? I'll turn it over to Eric here for a few minutes.
Yeah, I think one of the hardest things with trademark infringement is the ability, and probably the most important thing, is to know, what fights are worth fighting and which ones perhaps are on that in that gray area that you kind of wait and see, or you kind of see if it's going to be a direct impact. Because if trademark owners are doing their jobs right, then, and they're consulting with lawyers and kind of getting a good strategy in place, then they will take care of infringement before serious damage is already happening. If you're going to someone after you're losing business because someone's using a similar name, and you're waiting 6 months, a year, it's until the damage is significant. By then, it's already going to be very difficult to kind of unring that bell. And so a lot of trademark owners are responsible for looking at what's likely to cause confusion. What on the horizon, that if certain circumstances happen, yeah, is this something that's likely to confuse? And I think that's kind of the standard that we're always going to use, is by the consumer, the relevant consumer, not the very close paying attention consumer, not the kind of completely lowest common denominator. Relevant consumer, are they likely to be confused? And that question is obviously going to be a very difficult one to ask. But some of the questions that we look at when we are evaluating an infringement is first the eyeball test. Eyes and ears. When you look at something, when you say it out loud, does it sound similar? Would the relevant consumer think that that might be somehow related to to the trademark owner's brand? And if the answer is yes, then you kind of look at how similar are the goods and services. So if one is for motor oil and yours is for supplement products, then chances are consumers are never going to think that a motor oil company is offering supplements. But there's a lot of exceptions to that, and I think that there's a lot of play between how similar the mark is for how similar the goods and services are. And what I tell clients all the time is that varies by jurisdiction, but one of them is an 11-factor test to determine likelihood of confusion. And the 11th factor is anything else that's relevant to confusion. And so, with that in mind, there's so many different factors that you're looking at and so many things that go into it. But I think that really thinking of it as this idea of, eyes and ears, look at something and then try to put yourself into the consumer's shoes and say, is confusion likely? If certain things were viewed in a certain way, if I kind of if you're at a bar and you're squinting to see what the label of the liquor looks like, those kind of circumstances are all taken into consideration, and something that we really should be thinking about from that perception of the consumer, and kind of thinking ahead, not just right now, is it a problem, but could it be a problem in 6 months? Could it be a problem in 5 years? If a competitor or someone really does start to kind of spend significant amounts of money, is it going to be a problem for you? And I think that's kind of a very high level thing of what to think of when we're kind of considering whether something's worth sending a letter or doing other kind of enforcement with.
Yeah. And sometimes you'll talk to clients and they'll be really upset about something, and you'll have to remind them that trademarks can coexist, right? So, I mean, here's some examples, of places that you might have similar name. You have Delta Faucets and you have Delta Airlines, and you know, doesn't seem likely that people, you're like, wow, both these are both really big brands and they're sharing a name, and yeah, that can happen because one's a faucet and one's an airline. Um, Although Eric, I suppose somebody never made the argument that you could have a Delta faucet and a Delta plane somewhere, but
No, I mean, and that's a part of it too, is that when we're talking about high level infringement risks, that sometimes people just decided that they're going to coexist with each other, and after a certain amount of time you lose the ability to really say, yeah, I think this is confusing because they've been coexisting for 40, 50 years. That does get to be a difficulty. And one thing we even talked about, Josh, go back to the last slide.
yeah.
So Stanley Drinkware and Stanley Hardware, we were just talking before the presentation that I was like, I don't think I realized that, because you do see like Stanley, the old Stanley drinkware company, was really, yeah, touted as a industrial level. This thing can take some damage. I thought, oh, that's for tool sites. And so, they're not having any problems with that. But I'm a pretty sophisticated trademark attorney, sophisticated in quotes. But even then, I was like, I never really thought about it. But to see that they're completely independent companies, I think that that's a great example of one that peacefully coexists, and there hasn't been damage. But you could see where that might come into play, where those could be related to each other in one universe. But they've been coexisting for so long now that it becomes difficult for either party to say, well, confusion's going to happen, because probably would have by now. I
Yeah.
think the other one, the next one with the Dove soap and Dove chocolate, I think that's great. We had a Joshua, and I will throw myself on this sword that about 8 or 9 years ago, I had this great idea for a marketing thing that Dove soap and Dove chocolate. Let's put those in a mailing together and mail them to folks and say, look at this example. Can you tell the difference?
Yeah.
Like, yeah, that's why trademark law is important. And the feedback we've got is that it's like, oh yeah, I guess that was a kind of clever idea, but this chocolate tastes like soap. And so I'll never forget my great marketing idea, but at the same time, perhaps no one was going to be confused, and maybe it was not my finest moment of marketing genius. But that's an example that I love using because it's just so different from a product standpoint that they're unlikely to ever interact with each other in a way that would cause confusion.
We did mail people a lot of soap bars and chocolate, and that, and if yeah, that's I forgot about that one. That's pretty funny. Yeah. Well, when you run a business, you win some, you lose some, and that was we had cool boxes. I thought it was a cool presentation, but I don't know that one really worked out for us.
Yeah, swing and a miss.
Uh, uh, I'm thinking about our paralegal Madison, who's still here. She was back with us back then, and if she's on this call, she's probably got some PTSD from having to assemble all those boxes. I had her laid out in the office. Anyhow, um, so no, that's a great setup for sort of where we go here. So when if we decide and so much goes into and I one of the things that I come back to all the time is we have people call us all the time be like I want to send a demand letter, and every person I start and engage with a demand letter, a lot of times they're like, well, how much is it just to send a letter? And I'm like, no. I was like, we're not just gonna write a letter and send it. We're gonna do research and we're gonna advise you on the pros and cons of sending this letter because you have to, I mean, there's so many things you have to make sure besides the fact there's actually infringement. You have to make sure that for some reason that enforcement target you've decided is now a problem wasn't actually out there before you. Because if you send someone a letter and they were out there before you, all of a sudden the hunter becomes the huntee, and that's no fun. But not only do you have to do that kind of research, you want to make sure that you're counseling a client about, hey, look, there are situations here where this might be in a gray area, and there's no problem in enforcing in a gray area. You want to try to create a circle, a moat, so to speak, between your brand and others. But you want to be aware of what the pushback is going to look like. You want to be aware of what you might run into as part of this process. So we're not just going to jump in without actually doing some research and some counseling. And so, um, you know, people are sometimes receptive to that and other times not. But that's part of our ethos and how we're going to do it. Um, so when you get into the question of, okay, what do you do if you're not, jumping into a lawsuit? And, so first things first, and this is going to be pretty obvious to any attorney here, is you're normally going to start with a cease and desist letter, right? Or some kind of demand letter of some kind. And we'll talk about that a little bit in a second, because we have sort of a slightly different approach on demand letters, maybe the average law firm. But the first thing you want to do is get the notice out there, inform the infringer of the issue, give the parties a chance to have a conversation, try to resolve the dispute if they can. Um, we typically tell our clients, much like the idea that we're not just going to spend and give you a template letter to send out. We're probably somewhere around 2 or 3 thousand. And we're giving you some costs here because we thought it'd be helpful. Not that you have to use us, but just to give you an idea of like what the typical cost that we see with it is in a firm of our size. But so typically we're expecting about $2 or $3,000 in time to do the research we want to do to stress test the enforcement strategy, make sure all those things are in line that we want them to be, and then actually draft and send a letter. Um, and that, very helpful in getting conversations started a lot of times, because the vast majority of people, sometimes people say, well, aren't they going to throw the demand letter in the trash? Most people don't. I mean, sometimes they do, but a lot of times we get a response. It might not be the response you're always looking for, but it at least is a response that gets a conversation started. Um, the other thing that we can kind of get into, and this is, something Eric has done a lot of, and so Eric, I'll let you talk about, but the idea of doing takedown notices, because so much infringement you see today happens to be on like a third party platform. So it's not that you're sending a note and saying, hey, you're infringing on our mark and you're selling this product on your own website. You happen to be selling it on Amazon or selling it somewhere else, and that leaves some opening for us to do some enforcement there.
Yeah, and I think many attorneys on this will be familiar with the concept of the online marketplaces and kind of the unbelievable tactics that are used by it is a very kind of Wild West feeling when you're looking at the way that some folks use trademarks in ways they're not supposed to. But every major, I think, reputable, and I'll say reputable also in quotes, but every major marketplace online is going to have some takedown mechanism. So it kind of is something that they all want to avoid contributory liability. So they do not want to be responsible for the infringement of their users. And so, in order to say, well, we don't have to take action against our users until we actually know that there's a problem, they have takedown notice procedures. This is very, if we were talking about copyrights, which we're going to focus mostly on trademarks, but copyrights, they have an entire regime. It's called the Digital Millennia Copyright Act, Millennium Copyright Act, and it has a whole thing that you can do to get safe harbor. There's nothing like that with trademark law. It's largely a system copied from copyright and occasionally tested by folks who don't get infringement taken down as quickly or ever by some of these folks. But takedown notices are essentially a report that is sent from the trademark owner to the marketplace that says, here's what my rights are. I want you to remove this product. And many times they will take it down. There's usually a counter notice procedure where the other side can say, no, I'm authorized to send this, or that I think this person's wrong, and here's what I'm doing about it. So there is a system of doing that, and a lot of the times that'll solve the immediate problem, especially when you're dealing with overseas sellers. Sending a letter in that case, you never know where it's going to go. Sometimes you can't easily get contact information for them. There's a lot of things that you are difficult to do when you kind of have this shield up that Amazon and all these other folks put between you and the seller, where you're not sure exactly who the seller is. And even when you are, you don't have direct contact information for them, and mailing a letter is not going to be effective. So the takedown notice helps. It gets the immediate infringement down, and you have to provide a lot of information, and sometimes you have to follow up multiple times. I think this is an imperfect system. We're currently dealing with a marketplace that just is like, I don't know, it's unclear from your report why you're reporting this. I'm like, I can't be any more clear. And by the fifth time that I finally followed up with them, this lower level support got elevated, and then finally it got to someone who actually took action. Probably took a week longer than it should have, but there is this kind of imperfect system in place for a lot of these, and a lot of them even have systems that I'm sure many of you have heard of, like brand registry. There's kind of this growing pseudo-legal system that is governing a lot of other trademark law practices that allow you to kind of monitor the marketplaces more effectively and quickly file takedown notices. I think you need to be careful, though. There are a lot of services that say, hey, we'll file takedown notices for you. It's not a lawyer behind it. It's kind of automation and general kind of use of AI tools and stuff like that. You could file takedown notices that are not infringing, and you could be responsible for them. And it is my pleasure to send angry emails back to folks when our clients get takedown notices that they're not supposed to. And it is usually a problem because it's anti-competitive. There's a lot of things wrong with filing false takedown notices, and everyone needs to be very careful when they're submitting them.
Yeah, I think that's a great point to highlight here, especially if you're dealing with clients who use one of these services that claims they'll just find infringement and take it down. That's not a legal service, and yet they're taking legal action. And we've actually seen lawsuits, and there have been lawsuits where folks have gotten sued for sending takedowns that they shouldn't have sent. And so this is where I go back to, I think clients, especially, we're getting into this AI world where they're like, hey, they view this as almost a game, like who they can take down to get away from their listings, or who they, or who's taking money away from them, and they're mad about it. And so really counseling the client on what's an appropriate time to submit a takedown and when's not an appropriate time. Some clients don't want to pay for that advice either, but the ones that, we've had some pretty large clients who we've talked out of using those services to do the takedown. So yes, they can help us find everything, but we need to have some kind of vetting process so the client doesn't have liability. And that's a huge, huge flag there, Eric.
And something to touch on. So David in the chat that said, do you have to have evidence of actual confusion before issuing these kind of notices? And the answer is no. We kind of briefly said, if you're doing it right, you should be finding these kind of infringements before there's actually confusion happening, because actual confusion is actually evidence of that is very rare. To have someone come to you and say, hey, I thought you were this other company, tends to be very difficult. Then it's more likely the person encountered it, moved on, and never even really, thought to reach out to the company and say, "Oh, I thought you were a different company." And
Yeah.
so that's where it comes down to kind of that analysis of the checks and balances of, is this a good case to bring? How much, what's the risk I'm taking doing it? But it should be in as many cases as you can before there's evidence of actual confusion. And sometimes if you have actual confusion, that's when you put gasoline on the fire, because harm is actively happening in that case. And those are the ones that you got to put high priority, deal with it immediately, versus the ones that could turn into confusion, or there might be some that isn't as obvious.
Yeah. No, that's a great point. The key term with trademark cases is likelihood. I always find of confusion. So not actual confusion necessarily, but the likelihood that there could be. Um, And Eric, I'll leave you keep going here. So the next step in enforcement options would be not, there's now you get into somebody's filed a trademark application for something that might be similar, and you want to try to not only deal with the potential for the issue in the marketplace and the stopping of the sales and goods and services, but looking at, what do we do about this trademark application that we're now concerned about that might infringe on our clients?
Yeah, and real quick before we move on, we got a
Mm,
question in the question and answer section that says, when is an instance where you wouldn't take something down? I think that there is something called the first sale doctrine in the U.S. It is, if I buy you know a bag or something and I want to resell it, and as a used product, I'm allowed to do that. I'm allowed to find a product, buy it, and that first sale is the only thing that the brand owner in most cases can control. And so if someone is reselling a product that they legally purchased and they're accurately relaying that information to the consumer, then that is a really difficult thing. I would tell trademark owners that there needs to be very specific circumstances in place that would say file a takedown notice on eBay against that person, because they're trying
yeah.
to sell a used product, and we have an entire industry of resale that is completely legal and should not be, subject to takedown notices. Now, if that is materially changed, and the example that I think of is that, hot cosmetics in a warehouse for a year that are melting, and colors off and all those kind of things, those are no longer, in my opinion, in most cases, I'll do all the lawyer things of equivocating, but in many cases that may take it out of this idea that this is the same product that they originally bought. It is changed in a way. For example, and in the chat someone said, if you take a bag and make something new out of it, that gets to be, it gets into, I should have a large sign behind me that flashes "it depends." But there's circumstances in which, if there's a warranty and that warranty is material to the original buyer and the seller didn't say, "Oh, actually this is not subject to the warranty," that could be a case where you could take it down, even though it is a genuine product. So there's things like that that are just very much a minefield, and a lot of these services are just like take it all down, the carpet bomb approach. I think that you need to be very careful with those. But yeah, and that's kind of just with takedown notices in general. I would take a very kind of scalpel approach to them, because I think that there's just too many people out there that are looking for a fight if they get a takedown notice that they shouldn't have gotten, and it'll work until it doesn't. But yeah, then there's the next kind of set of tools. I gave a presentation once that I called these kind of these are your, like, your Batman tool belt. This is the, what else do you have beyond the kind of normal marketplace kind of enforcement. And a lot of monitoring, a lot of kind of things are what happens if someone files with the Patent and Trademark Office for a name that I think is similar to mine, because Patent and Trademark Office filing is going to give much more scope of protection. It's going to give nationwide rights. It's going to give presumptions to someone that if they're able to register it, it's going to be way harder after the fact to tell them to, abandon their mark and not use it than if you catch it before they register it. There's a lot of exceptions to this, but that is a great way to kind of try to get in as early as possible to get the costs as low as possible. Because if you can, before they invest in the brand, if you can get a real conversation about infringement, that's always going to be cheaper than if they dug in and they are saying, well, no, I already spent, all this money on marketing. I'm digging my heels in. That's going to be more expensive. So one of the interesting things that you can do is called a letter of protest. Normally, a trademark filing, and this kind of goes into some of our other CLE presentations we've given. Normally, a trademark filing, there's no interaction with the examiner by third parties. So it's this idea of ex parte communication. No one can try to influence the examiner. They do it independently. They don't even, their initial examination is not even the filer can go call them and be like, hey, no, make your examination this, and this. But there is a system that was codified into law a few years ago, I think 2020 or something like that. That's called a letter of protest. So essentially what you're doing is you're submitting to a not third party, but a petitions group of the PTO completely separate from examination. And you can give them evidence of what you think why a trademark should be refused. They'll look at it, they'll say, does it meet our standards? And if they do, they will obfuscate any of your information and they will only send the results to the examiner and say, hey, you should look at this. They won't give any other kind of context. And that'll give the examining attorney that they likely, if they were doing their job to the fullest extent, then they would see it anyways. And a lot of the times it's a little bit, I've heard from them, annoying because it's duplicative, but examining attorneys are spending on the average 45 minutes to an hour on a trademark examination. So any additional help that they can be given, I don't think that's a problem. But what happens if something gets through the examination process, it gets approved by the examiner, and you still believe that there's likelihood of confusion? There is an entire process called a trademark opposition. It's very similar to federal court rules, but it is in an administrative court or an administrative body called the Trademark Trial and Appeal Board. And that can be a way that you can stop the registration of a trademark before it registers, and using the federal rules of civil procedure. And a lot of the times, I think that I saw, don't completely quote me on this, but I think 60 to 70% of these, once you file an opposition, the other side doesn't respond. It's a default judgment. They either have looked at it, they've said, we want to, sometimes, unfortunately, it's because they just don't want to proceed. It's not worth it. Or they look at it and they're concerned that they're going to get an infringement follow-up or something like that. So a lot of these will get go to default judgment, or they'll settle early. Trademark cases can and should settle. We'll talk about that more with litigation, but I am a settlement first kind of person when it comes to looking at the cost benefit analysis. Almost always it is in the both parties' interest to settle. But if you don't, like federal litigation, trademark oppositions can get expensive, but it also can provide very wide-ranging protection in the future for registered trademarks. And so sometimes you need to oppose them, and there is an opportunity to do that. It's a 30-day period at the end of the examination process. And so it's very careful to kind of, as you're monitoring trademarks that you might be concerned with, just be aware of that date. Because once that opposition period ends, you can't oppose it. You have to then later cancel it, which has a whole different level of evidence needed to cancel a trademark versus opposing it.
Yeah, and just to piggyback on what Eric said there, Eric, I lost count, but I think there's been over 500 trade of these kind of proceedings we've done, if not more.
Yeah.
And very, very small number of them actually end up going to distance and going to trial. There's so much room for settlement in these cases. And one of the benefits, I think, of an opposition, and we talk to clients about a lot, is by filing the opposition, you're forcing the other side to respond and spend money themselves, just practically speaking. And so they're then going to be more likely to want to settle with you because, everybody's got the incentive. It's not just a demand letter that has no teeth to it. It's, if I want this trademark, I've got to talk to these people. Otherwise, I don't get my trademark. So it's if you're having trouble getting someone to the table, it is a way to force them to get there. And they're more likely to look at it themselves and say, no, I don't want to take this to trial. I want to try to find a way to work with these folks. And so, and then again, on the flip side, like Eric said, we've got the cancellation process, which is similar to the opposition process, but a little different. So it's same kind of administrative court, same type of cost typically.
And there's also a lot of junk as a lot of your monitoring for your clients, or if you're a trademark owner, is going to be about looking at some of these foreign filers that file for everything under the sun and are not actually selling any of it. So there are also tools like expungement and reexamination to help get junk off the register, what we call deadwood, of marks that never should have registered in the first place. They're using it for, they put fake specimens in. They never should have filed it. They just wanted to get brand registry for something completely unrelated. That happens, and there is mechanisms that are less expensive than a full-blown sending a cease and desist letter or anything like that. You just can get it expunged or potentially re-examined. That's an entirely, I think, different presentation that we can do of all the
Yeah.
different ways to challenge the trademark rights of another person. But that's just something to keep in mind. There's not, not everything needs kind of our next topic is, don't jump to litigation. There's other ways you can solve problems that might not be definitive. You might have to try a few different ones of these approaches that are all going to still be more effective or more cost effective than, and sometimes more just effective in general to deal with the problem than jumping straight to kind of hardball litigation or overly threatening cease and desist letters. That's just going to cause people to dig in. Another one of those is
Yeah.
domain name disputes. So there is a system called the UDRP. It is a mandatory arbitration that everyone who signs up for a domain name has agreed to, and so everyone is subject to it. It is very specific of when you can do it. It's for cyber squatting or bad faith registrations. It's not for infringement. Sometimes someone can have registered something in bad faith, and there's circumstances, but usually this is not a guy's using a similar trademark to me, I want them to remove it. It is someone who is squatting on your name, trying to do a slightly typo just to get people to go away from your website to theirs. It's another one of those kind of scalpel approaches. This is not a one size fits all approach. It is something that you use sparingly, and the costs are the filing fee itself is, I think, depending on which arbitration firm, is very high. So you have to just be
Yeah, it's
aware of
like
kind of the
16,
investment.
$1,700.
Yeah.
Yeah, yeah. I mean, we've used it before ourselves. We had, I mean, I forget the exact domain, but it's something like gerbenlaw.us or something. And then they put up a fake website and switched our pictures and names around a little bit. And there's sometimes where we can get the host to take stuff like that down. I think in one case we did a domain dispute. So it's, this is one of the tools in the toolkit, as Eric said on his what do they call it, the bat belt, that you can take out when it's appropriate, and if you really, and it gives you sometimes an opportunity to recapture a domain that might be actually helpful to the organization too. So
Yeah.
but yeah, we have, I mean, like, the cost pressure here is it's that the average cost $3,500. That adds up real fast if you've got a bunch of these, right? And so a lot of clients, look for other opportunities first, but it's one of those things that that we try to use when we need to. So the next thing we want to kind of get into is this idea of, okay, so we've been talking a lot about the fact that trademark cases should settle, and that's because a lot of them should. There's only a finite amount of words in the English language, and so you're going to have those coexistence situations that we've described earlier in the presentation, even for large companies. You're also going to have situations where maybe there is something that's too close, and you don't need to sue the person if you can work something out. So here's just some things that we've considered over the years and have applied and have been really helpful. The first and the most common one that you'll see in trademark disputes is just allowing someone to have a phase out period. We had a client the other week where we got a couple thousand units of inventory. We've got someone that doesn't like it, but they're willing to let us sell through the product because they know if they don't, like, we're not going to settle. Like, it's a very much on the edge case, and we could probably push back. But nevertheless, our client's happy to say, you know what, I got this inventory. I could do something else. I can make a change here so that they're not mad at me and I don't risk litigation. But I need them to let me get this product sold because I don't want to waste it. I don't want to lose the money of the inventory. So especially if you're on the offensive side and you make that, and you don't want, and your client doesn't want to constantly be in litigation, if you're like, look, if you guys change this, we'll give you 6 months to sell this stuff out. Well, you've just given them a lifeline. And a lot of times that works. And you don't, so again, just trying to encourage your client almost too, like, hey, you're going to have to see this for a few more months. But if we let them do this, they're willing to make this change. You're not going to spend tens of thousands of dollars or more in litigation. So it's kind of a win-win at that point. And that's something that we offer on both sides when we're on the offense and on the defense. We try to bring that out as a possible solution. Something that sometimes works, but does not work as often as people think it does, is buying out the other party's rights. I get questions all the time from a client. Well, what if I just bought out their rights, or what if they buy me out? Very rare that two parties see eye to eye on what something's actually worth. It's always the old saying, "The beauty's in the eyes of the beholder," and so I've seen it work sometimes, but if a client's coming to you saying, "Oh, well, just tell them to buy me out, or I'll just buy them out," we're like, "Yeah, but I don't know that's going to really work."
Well,
And
and trademark law doesn't even work. Like a lot of the times, it's
well,
like, well, yeah, just buy it. So, like it is this thing of, well, you have to have goodwill behind the trademark that you're selling as well. And I remember
yeah,
being on a call with a client, and the other side said, all right, they want to talk, business to business with the attorneys on the phone. I'm like, great. That means we're getting somewhere. We all get on the phone, and person says, yeah, I will sell my rights for $1 million. And our client was like, 1 million US dollars? Like thinking like maybe he like was like we were talking about like, like yen or something like that. And it was the look of confusion on the client's face as to where this $1 million came from. And then like kind of prodded it like, oh well, like where did you get that number from? And it was like, that's the number. And I was like, well, I mean, I don't know where to start with that because, that person had
maybe
not
Austin
even,
Powers.
they had
Yeah,
been using it in like, Arizona for like 6 months. And they're like, yeah, that's what it's worth. It was like, according to what? And it was just such a bizarre circumstance of like, couldn't have given me a heads up. Could have just saved everyone a lot of time. But I think you're absolutely right. There is this kind of disconnect, and people start to see maybe money signs when they have. It's more on the defense side that you see folks kind of being like, "Well, you could buy it from me," and you're like, "All right, well,
yeah,
I think that's always a difficult thing to actually accomplish." I think you're absolutely right.
yeah. So as far as things that tend to work more often, these are the types of here's sort of a handful of things that we do a lot when we're enforcing marks. Because sometimes, and we touched on this before, your client may own rights in a trademark and or a family of marks around a particular name, and other people may file trademarks using that name or something similar, and you're just like, okay, well, if they're in a very narrow space and away from us in the marketplace, this should be okay, but we need to make sure it's there, and we need to make sure it doesn't expand into our area. So a lot of times when we're doing enforcement, we're actually asking the other side to narrow down the claims being made in their application or put narrowing language in it. For example, you might say, if I'm enforcing the Gerben trademark for Gerben Law Firm, I had an instance where there was another lawyer who didn't have the last name Gerben, but something very similar to my last name. And I said, okay, I'm not going to bother you, but you can't offer IP services or trademark services, because if you do that, then I think we're actually going to have a problem. And so in his trademark application says all the foregoing except for, intellectual property services. And then there's an accompanying agreement that says he's not going to use it for that too. So the idea that you can let somebody use a name if it's similar to yours, but still create that moat because you're going to keep them away from what you're doing. And this other guy happened to be a personal injury lawyer. And so it's like, yeah, I don't do personal injury law. I just don't want you. Sometimes personal injury lawyers dabble in trademark cases. I don't want you dabbling in trademark law because you're gonna probably wreck our name. So that was just the idea, and that works in so many circumstances. You'd be surprised. I mean, we've probably settled hundreds of cases where we just said, hey, look, as long as you use this name, right? And then point two is like, maybe their name includes two words and your name and your name has two words and they both share the same first word. Well, as long as they don't shorten it to just that one word, which you're sharing, and they keep using the full name and they limit it to these goods and services, hey, we probably don't have a problem here. But like Eric said, if you don't have that conversation with them now and that business grows and then they start offering other things or they want to shorten their name and you never have had that conversation with them, good luck stopping them, because now they're going to have a war chest and they're going to be able to hire the large law firms to come in and tell you every reason why they don't have to have any restrictions, right? So getting to people early while they're small, they're willing to kind of negotiate and put these restrictions in place can really keep that moat and that elbow room around your brand or your client's brand. The other thing we've done is like restrictions on channel of trade. So for example, I have some agreements. I said, okay, our client's really big on Amazon. You can't sell on Amazon because if you bring this product on Amazon, it's going to cause a huge amount of confusion. But if you want to sell it direct to consumer off your website, no problem, right? And so the idea is that you can have these different channels of trade where you could say, hey, look, this is an important channel for us. This is, where we can't have you showing up and we don't want you near us. But if you're going to sell this another way, that's fine. Another example would be we had a client that made or that was actually a restaurant chain, and there was somebody that was selling a brand of food that was a same name. Well, the food brand was not selling at retail. They were just selling it in bulk to restaurants. So, and our client's a consumer facing restaurant brand. And so the food brand never really appeared in front of a consumer. And so we said, look, as long as nobody's using this brand on their menu to say this is a certain type of product, and this is literally just being shown to restaurants behind the scenes that they're buying, and it doesn't reach the consumer level, then we're okay. And we were. And so those are just examples of like where we can, put in writing, these are your restrictions. Don't sell it outside of this channel. And hopefully, things will work out. Another great tool is geographic restrictions. Got another case right now where we've got a client who there's a few people that have popped up over the US using a similar name, but they're more local businesses. And we've gone to them and said, look, we don't really like this, but if you don't operate outside of Nashville or you don't operate outside of Orlando or wherever, I'm making up these cities, we'll be okay. And we put those restrictions in place and say, look, you can operate in this area, but don't expand. Don't start to franchise. Don't file your own trademarks. So, it's not completely ideal, but we don't have to necessarily go out, and especially because the trademark case was good, but not great. We don't have to open up litigation. We can just kind of make these small businesses, let them continue to do what they're going to do, but make sure they're not going to grow into our client essentially. And then the final one on this is that, well, I kind of touched on that, but that the expansion restrictions. So, hey, you might be offering like Google, you might be doing search today, and then they go off and they start doing driverless cars, and now they're doing AI and they do all these things. Well, if you get to a company early and you say, look, we're okay if you do this, we don't want you expanding and offering a whole suite of products and services because then it's going to look a lot potentially like us. So you could say to someone, hey, you're making this widget right now. As long as you just make this widget and nothing else, no problems. But the minute you expand, we got an issue. And getting that agreement in place locks them in, and you keep your moat, you keep your elbow room, no problem. So those are, in our mind, some of the better, tips for how, when you're talking to folks and talking to your client too, to be like, hey, look, you don't have to litigate this. These are some restrictions we can ask for that might be really meaningful and help us get a resolution here that everybody can live with. So I see some activity in the chat. I don't know if that was questions or just people,
some good conversations, but I think
oh yeah,
that
nothing.
one of the ones in here I think is actually really helpful is this idea that trade names, can you register the trade name of another person potentially if you don't use it as a trademark? And I think I will say that's not a good idea to do it on purpose. I think there's other laws that could say, well, filing as a trade name of someone else, but trademark law is about what the consumer sees. So we should just be very aware that you could name your company 12345 company, and you could own a trademark that's completely different than 12345. And I think that that's it is really about consumer perception of it. Now, it is never a good idea to try to impersonate anyone or anything like that. But realistically, if it's only being used in an administrative way, then business names tend to be less likely to be trademarks than brand names and things that are in headers and footers and all those kind of things that and that are on packaging with those kind of things. And and I think another thing that came up was this idea of with lawyer marketing. I'm kind of paraphrasing here, but one thing to be careful of, I think, is when people are using surnames, that there is at least some right to use your full name accurately to say, I do business and I am this person and this is my name. That tends to be different than trademarks. So it's a very fine line here of, just because my name is Eric Beyonce, I can't go out there and say I'm Beyonce. That would still be something that could confuse consumers. But if my legal name was Eric Beyonce, I could say my name is Eric Beyonce, and here's my dance really well. The which is true. I did change my name to Perrott after that dispute, but no.
I
So
mean,
I
if
think
you're
that
going to come
there's
with some dance moves on the next CLE, I think we'll get more
that's a great
attendance
idea.
for
No,
what it's
I'll
worth. Yeah.
consider it. But I think that there are some kind of, I mean, it goes back to this idea that there's so many, it's so fact based. And I think that that's where tiny little changes in fact patterns are going to completely change the recommended way to approach it. So I will be self-serving and say if you're a brand owner who's on the call and you don't have a lawyer yet, find one that you trust, because I think they can really help navigate that minefield of, well, is
Hmm.
this the same as this last one? And the answer is probably not. There's probably some nuance there that you want to consider before sending that letter or filing that takedown. And I think really good just to kind of have that reality check as often as possible to avoid running into additional costs, or in the worst case scenario, potentially getting like a declaratory judgment or something like that against you.
Yeah. And it's great points. We're running out of time a little bit, so I want to touch on litigation. There was one other question that hit close to home, and they asked us, Eric, how did we get the trademark on Gerben since it's a surname? Well, the answer is because we've been in business long enough. So when we first filed it, certainly you get the merely surname refusal. You get on the supplemental register, but after 5 years of use, you can file and say you have acquired distinctiveness in a surname. So now we are safely on the principal register after all these years of being in business, and that gives us stronger rights. But yeah, certainly if we were ever litigating around the name, there'd be some argument that it is a surname, and that weakens our mark a little bit. Actually, when I was starting the firm, it was a large consideration. I was wondering if I should choose one of these kind of random names or just go with the traditional last name approach. And I ended up doing, even though the marketing person in me wanted to be something else, I just felt like I wanted consumers to know they're hiring a traditional law firm, not a legal Zoomer equivalent, type of thing. So, I want to touch on litigation before we go, just because it's a huge part of enforcement, but we don't have a ton of time. What I will say about litigation is it's extremely expensive and time consuming. And the one thing that we have learned in doing it over the years is that you really have to make sure your client is on board and ready for the fight and ready for the costs, because a lot of clients will have an emotional response like, yes, I want to sue them. Yes, here's the first 15 or $20,000 to get the complaint filed. But then the minute things get tough, they are out, or they don't want to be a part of it anymore. And so, in really having a conversation about what litigation means to a client before you start the fight, because you can't just pick a fight and walk away. And these cases can get very complex very quick. Now, the one caveat to that, and I've seen this work on both sides. I've had clients that have gotten sued, and we have sued people where the minute the complaint gets filed, the other side folds like a house of cards because they want nothing to do with federal litigation. And so you do want to think about using it as that tool where you say, hey, look, we could file this complaint, and if we're lucky, the other side's just going to wave the white flag immediately because they're going to get a quote on what it's going to cost to defend the case, and they're not going to want to deal with it. But if you've got somebody on the other side that's up for the battle, now you got to be really ready with some serious money. And look, we're a very small law firm, and if we do litigation, it is, I think, very tightly managed, well managed, and we try to keep costs down, but it can still take us $1 million to get somebody from the filing of a complaint to trial. And it can cost even more. Reasons for that are everything you do is time consuming, a lot of depositions, and you typically need to hire experts. And experts, literally several hundred thousands of dollars, if not more, go to that total. So trademark litigation is not cheap. It's not for the faint of heart. It's typically not done on contingency because very hard to predict what a judge or jury is going to do from a damage perspective. It's not like personal injury law. So you really got to be ready to make an investment if you feel like you need to go to litigation. And that's why we spent so much time in this presentation today talking to you about all the ways you can handle it without using this tool that's in the toolkit, nevertheless, but something that typically is outside the budget of a lot of companies that we
I'll
represent. Yeah. And
no, none of the other ways we discussed will have a result in a binding
yeah.
um, thing that a court is enforcing. So yeah, the stakes are high with litigation, and that's why part of it is the reason why people litigate is because sometimes you have to. And
Yep.
at the end of the day, you'll get a court order that says this is what must be done, as opposed to kind of pot shots with takedown notices and letters. Everything else is just kind of prelude, but this is it is so expensive because of the stakes are just so high. This is where damages get into play. This is where costs and everything is very so. I don't want to, yeah, that is why people litigate, but also why
Yep.
you should really consider alternatives if you can.
Absolutely. And Lacey, I'm going to let you go here in a second. We're going to not get to some of the slides today. We've
Yeah.
sort of really anyhow. So we'll send those other stuff in the slides, and we'll certainly try to cover those other materials in future presentations.